Have you ever had a neighbor whose constant noise, weird smells, or maybe even late-night tuba practice drove you absolutely nuts? It's something we've all felt, but it's also a really complex legal issue. So today, we're going to break down the law of nuisance and figure out what your rights are to a little peace and quiet.
So where does the law actually draw the line? I mean, when does your neighbor's right to do whatever they want on their property suddenly cross over and start violating your right to enjoy yours? Can you actually, take legal action to make them stop? Well, the answer is often yes, and the legal tool you'd use is called nuisance.
Okay, let's get the official definition out of the way. Legally speaking, a nuisance is any unreasonable interference with your ability to use or enjoy your property. Now, that word right there, unreasonable, that is the key. It's the word that fuels entire court battles. So let's really dig into what the law thinks is unreasonable.
Now, nuisance isn't just one big, simple concept. The law actually splits it into two main categories, public and private nuisance. And you've got to understand the difference because it changes everything: who can sue, what they need to prove, the whole shebang.
So on one hand, you have public nuisance. This is the big stuff. Think of a factory polluting a river or someone illegally blocking a public highway. It's something that harms the whole community. Private nuisance, though, is much more personal. It's a specific interference with one person's property rights, and that's exactly where our noisy neighbor scenario fits in.
This table really lays out the differences side by side. Check this out. For a regular person to sue over a public nuisance, they have to prove something called special damage. That means they were harmed way more than the general public. But for a private nuisance, you don't have that extra hurdle. For the rest of this explainer, we're going to focus right in on private nuisance, because that's the battleground for most of these neighbor disputes.
And we are back to that all-important word, unreasonable. So how does a judge decide if your neighbor's 3 a.m. jam session is just annoying or if it's an actual, legally actionable nuisance? Well, it's not just a gut feeling. There's a specific legal test they have to apply.
To win a private nuisance case, you basically have to prove three things. First, that the interference was seriously unreasonable. Second, that it messed with your ability to use and enjoy your land. And third, that the person you're suing is the one who caused it. Sounds simple enough, right? But proving that first one, unreasonableness, that's where things get tricky.
And here's a really crucial point. The law doesn't really care if you, personally, are extra sensitive to noise or smells. The standard is objective. The court asks a simple question. Would an ordinary, average person living in that exact same spot find this interference to be a major problem? It's not there to protect someone who's just exceptionally fussy.
So how do courts figure out what an average person would think? Well, they look at a whole bunch of factors. Context is everything. Where is this happening? How long does it go on for? And how often? Is the neighbor doing it on purpose just to annoy you? Does their activity actually have some kind of benefit to society? All these questions help paint the full picture for the judge. And that leads us to this fantastic quote from a super old case that perfectly explains the most important factor of all, locality. It basically says what's considered a nuisance totally depends on the character of the neighborhood. The sound of a hammer banging on metal might be totally fine in an industrial park, but that same noise would absolutely be a nuisance in a quiet, sleepy residential neighborhood.
All right, all this theory is great, but the best way to really understand these ideas is to see how they play out in the real world. So let's dive into a couple of classic courtroom stories to see how judges have handled these situations.
Our first story is from a case in India called Dr. Raj Singh versus Babulal, and it is a perfect example of how physical discomfort can cross the line into a legal nuisance. So picture this. There's a doctor trying to see patients in his clinic. His neighbor decides it's a great idea to set up a brick grinding machine right next door. Well, this machine starts churning out so much red dust that it blows into the doctor's office, covering everything, the tables, the chairs, everything, and is causing real physical problems for him and his patients.
So the court had to decide, is this just a minor inconvenience the doctor has to put up with? Or is this a substantial interference with his property and his ability to run his business?
And the court's decision was crystal clear. They sided with the doctor. The judge said, yep, this is a nuisance. The reasoning was that any normal person would find a constant layer of brick dust in their workspace to be a major interference. The doctor wasn't being hypersensitive. His right to use his property was genuinely being harmed.
Next up, we have the classic case that gave us that famous quote about locality, Sturges versus Bridgman. This one is all about noise, and it brings up a really, really interesting defense.
So here's the setup.
A candy maker has been using these really loud machines in his shop for more than 20 years. No one ever complained. Then, a doctor buys the building next door, builds a new consulting room right up against their shared wall, and suddenly realizes the noise and vibrations make it impossible for him to work.
The candy maker's defense was pretty simple. Hey, I was here first. The doctor knew what he was getting into. And this raises a classic legal puzzle. Can you complain about a problem if you willingly moved right next to it? In other words, is coming to the nuisance a valid excuse?
And the court's answer was a massive no. They ruled for the doctor. This case established a huge legal principle. It doesn't matter if the problem was there before you were. You still have a right to the peaceful enjoyment of your property. Just moving into an area doesn't mean you automatically agree to put up with any existing problems.
Okay, so we've seen how you can build a nuisance case. Now let's flip the script. Let's look at the main arguments a defendant could use, and, if you win, what kind of remedies a court can actually give you.
So there are a few main defenses. Statutory authority basically means the law says I can do this, like a public railway. Prescription is kind of what the candy maker tried to argue, but it has a very strict 20-year rule. And of course there's consent. If you told your neighbor it was okay, you can't really sue them for it later.
And if you prove your case, you have 3 main remedies. The court can give you damages. That's money to compensate you. Even more powerful, they can issue an injunction, which is a court order telling the neighbor to stop what they're doing. And in some rare cases, there's something called abatement, which is a form of self-help, but trust me, it's legally very risky to try that yourself.
So, there you have it. You're now armed with the legal basics of nuisance. You know the tests, you've seen the court cases, and you know the potential outcomes. But knowing the law and actually going to court are 2 very different things. And that brings us to one final, really important question. Just because you can sue, should you? What do you think is the best practical first step to take with a disruptive neighbor long before any lawyers ever get involved? It's definitely something to think about.